Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about taking a motor vehicle without the owner's consent. Cases that should have gone to the Supreme Court of Canada, but didn't. Krista Pinkson owned a vehicle. She allowed her husband to use the vehicle. Her husband then allowed an individual by the name of Roger to borrow the vehicle without Krista's knowledge. Because Krista never told her husband that he couldn't give permission to other people, third parties, to use the vehicle, she was considered to have impliedly consented to Roger taking the vehicle and driving it. Unfortunately, Roger did not bring back the vehicle. And after Krista ultimately reported the vehicle stolen, Roger was involved in a motor vehicle collision. In determining who was liable for the damages arising from the collision, because of the provisions of the Motor Vehicle Act in Alberta, Ms. Pinkson was found to be liable as the owner, and her insurance rates were affected as a result. She argued in court that she didn't give consent to Roger, only giving consent to her husband, and so she was not liable because the motor vehicle was taken without her consent. And this case raises a very interesting issue about how consent works in relation to motor vehicles. Every province and every territory in Canada has an insurance system that essentially includes similar provisions related to the owner giving consent and the people that the owner gives consent to giving consent to third parties. So this is an issue that has national importance. And there needs to be very clear directions from the court for individuals to understand how they can limit the individual that they give consent to's ability to give consent to other people to use their vehicles. Because otherwise we see cases, and this has happened in every single province, of cascading liability as vehicles are borrowed and borrowed and borrowed again. And although this is probably not a problem for people living in large metropolitan areas, in smaller communities, which exist throughout Canada, borrowing a vehicle from a friend of a friend is something that happens as part of the community structure. So the Supreme Court of Canada actually had the opportunity to deal with a case that might address issues that directly affect smaller communities and potentially allow for insurance companies to avoid liability or avoid paying out claims, and also allow for people who are uninsured or people who shouldn't be driving to also avoid responsibility for the consequences of their actions as far as insurance is concerned by passing the buck in respect of liability to the friend of the friend of the friend whose vehicle was borrowed. The case raises important issues that the Supreme Court of Canada could have gotten into to make the insurance system more fair to individuals who are just trying to do the right thing by allowing their husband to drive their vehicle and not intending to give the world at large permission to borrow the vehicle through a series of third-party interveners. Unfortunately, the Supreme Court of Canada failed to consider the impact of this on individuals who are affected by the insurance scheme, and hopefully another case will come before the Supreme Court of Canada to clarify whether cascading liability can be found in these types of cases. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.